Hello friends, welcome to UGC EPG Pathshala. I am Dr. Rangeen Pallav Tripathi. I am a faculty of law at National Law University, Odisha. Today, we will be discussing about the module on basic principles of evidence law. The primary objectives of this module are the following: to understand the purpose of evidence law, to understand the classification of evidence in the Indian Evidence Act, to understand the concept of facts in issue, to understand the concept of relevancy of facts, to understand the concept of admissibility of evidence, to understand the concept of burden of proof, to understand the concept of standard of proof, to understand the concept of presumptions. The entire legal mechanism, including the criminal justice system, is based on the idea of proof. The Indian Penal Code deals with the criminal liability of a wrongdoer. The Code of Criminal Procedure deals with the procedural prescriptions while conducting a trial. The Indian Evidence Act deals with the various principles of proof. The essential task in any form of adjudication is proving facts. When X is making an allegation against Y and Y seeks to refute that allegation, central to this entire process is the responsibility of X and Y to prove facts which are favorable to them or unfavorable to the opposite party by producing oral or documentary evidence. The adjudication depends on the extent to which parties have been able to prove the facts alleged by them. The idea of proof in the arena of law is not the same as it is in the field of science. Unlike science, it is usually not possible for facts to be proved in a court of law in terms of unerring and unwavering accuracy. The court holds a fact to be proved when, as per the evidence, either oral or documentary, established before it, it believes with a reasonable appreciation that the fact is most likely to have happened. There is no objective and absolute proof of the fact held to be proved, and there is invariably a measure of estimation involved in the entire process. As it involves an exercise in assessment and estimation, it is essential for the entire process to be conducted within a structured framework of definitive and logical guidelines to minimize human error. In this module, we will discuss the primary principles under the Indian Evidence Act, which are designed to facilitate the process through which facts are proved by evidence. In this module, we will be discussing the following principles and concepts: classification of evidence, facts in issue, relevance, admissibility, burden of proof, standard of proof, and presumptions. We will begin with our discussion on classification of evidence. Facts are proved through evidence. As long as there is no evidence to establish something, a fact cannot be held to be proved, regardless of whether it is real or not. Proof of a matter does not always necessarily correspond with the truth of the matter. This is so because the court of law cannot afford to hold facts as proof without a solid basis. The court decides on issues far removed in terms of both time and place from the disputed event, and the judge has no personal knowledge of the facts which transpired. Thus, the court relies on the evidence produced before it to decide what actually happened in a given situation. The Indian Evidence Act allows for two kinds of evidence to be produced in order to prove facts. The first is oral evidence and the second is documentary evidence. Oral evidence refers to all statements which are required to be made before the court by any witnesses in relation to the matters of fact under inquiry. Thus, any testimony given by a witness in the court qualifies as oral evidence. On the other hand, documentary evidence refers to any kind of document, including electronic records, which are produced before the court for its inspection. This form will include all kinds of documents, starting from call records to purchase receipts. Now, we will discuss as to what is meant by facts in issue. Facts in issue refers to any fact which in itself or in connection with other facts is relevant for determining the existence, non-existence, nature or extent of any right or liability or disability asserted or denied in any suit or in any proceeding. Let us look at an example. X alleges breach of contract by Y and claims compensation. Here, X is asserting his right to get compensation from Y for breach of a contract. Some of the facts in issue in such a suit might be as following. First, validity of the contract between X and Y. Second, whether performance of A is excused due to some provision of law. Third, whether the conduct of Y constitutes a breach of contract. Then, whether the breach, if any, has resulted in any kind of loss for X. Without determining these facts, it will not be possible for the court to adjudicate on whether X is entitled to be paid compensation by Y or not so entitled. Ascertaining the facts in issue in any legal proceedings is the most crucial aspect of the entire judicial process. A litigant's fate in the adjudication depends solely on whether he has been able to prove the facts in issue in his favor or not. Then we move on to our discussion on relevance. Section 5 of the Indian Evidence Act asserts that evidence may be given in court for proving or disproving only two kinds of facts. First is facts in issue and second, facts declared relevant under Chapter 2. Chapter 2 of the Indian Evidence Act spans from Section 5 to 55 and it describes the various kinds of facts which are relevant in a legal proceeding. Evidence can be introduced in a case only when it pertains to facts in issue or relevant facts as enumerated under Chapter 2. This rule is to ensure that the time of the court is not wasted in hearing evidence which will have no bearing on the decision of the case. Let us look at an example to understand this concept better. X and Y enter into a contract in 2011. In 2014, X sues Y for breach of contract. In this suit, X seeks to introduce an evidence to prove that Y's grandfather was removed from service on the corruption charges. As such, court will not allow evidence to be produced for this purpose, because whether Y's grandfather was removed from service on charges of corruption or because of any other reason, and whether such charges were true or false has no bearing on deciding whether Y has committed a breach of contract or not. So, hearing evidence on this particular matter will be a wastage of time for the court. The chapter on relevance of facts contains several descriptions of the categories of facts which are relevant in legal proceedings. For example, Section 8 provides that any fact which shows or constitutes motive for any fact in issue is relevant. Thus, in the above example, if X can show that his grandfather was the one who had removed Y's grandfather from service and that Y became aware of it in 2014, evidence on the fact may be allowed, because in this scenario, knowledge of the fact that X's grandfather was responsible for the removal of service of his own grandfather may be a motive for Y to commit a breach of his contract with X so that X can be put in trouble. Thus, whether a fact is relevant or not depends a lot on the context of the case. Like Section 8, the Chapter 2 of Indian Evidence Act contains several other grounds on which a particular fact may be relevant in a particular case. Now, we move on to the concept of admissibility. Once the facts for which evidence may be introduced have been finalized, the issue which must be dealt with is the nature of evidence which may be introduced in the court. The nuances of this issue are captured in the concept of admissibility. It is essential that the evidence which is being produced in front of the court must be reliable and authentic, as it is on the basis of this evidence that the disputes are going to be resolved. The rules regarding admissibility of evidence seek to ensure that cases are not decided on the basis of evidence, the credibility and authenticity of which can be subject to reasonable doubt. It is for this reason that Section 60 of the Indian Evidence Act disallows hearsay evidence to be admitted. Thus, if the evidence is that A heard B saying something defamatory about C to D, then A's testimony that he heard B is admissible. However, X's testimony that A told him that A had heard B is not admissible. Thus, when it comes to oral evidence, it must be direct. In case of documentary evidence, it is mandated under Section 64 that unless the Indian Evidence Act so allows, documents must be proved by primary evidence and not secondary evidence. Thus, Chapter 4 and 5 of the Indian Evidence Act deal with various principles of admissibility which regulate the kind of evidence which may be permitted to be presented in court in different situations. Now, we move on our discussion to the concept of burden of proof. The concept of burden of proof in essence is a simple one. Who has the responsibility to prove facts in a court of law? Let us consider an example. X has filed a suit against Y for compensation, alleging that Y has committed a breach of contract by not delivering the 1,000 pair of shoes that they had agreed upon. The facts in issue in this can be summarized as following: whether there was a legally valid contract between X and Y, whether Y has committed a breach of that contract. Now, the question is, who has the responsibility to produce evidence in order to prove these facts? Is it X who must prove that Y has committed a breach of contract, or is it Y who must prove that he has not committed the breach of the contract? Whoever has the burden of proof has the obligation to produce evidence to support his case. Chapter 7 deals with the issue of burden of proof. Section 101 and Section 102 lay down the foundational rules regarding the question of burden of proof. Section 101 provides that whoever desires the court to give a judgment as to any legal right or liability which are dependent on the existence of some facts which he asserts, the obligation to prove such facts rests with him. It further provides that the burden of proof is said to be with the person who is bound to prove the existence of any fact. In the example that we just discussed, X is claiming his right to get compensation from Y. This right of X is dependent upon there being a legally valid contract between X and Y, and secondly, on Y having committed a breach of such contract. Thus, the burden of proof in this case, according to Section 101, will lie with X. Section 102 mandates that the burden of proof in a suit or proceeding lies on that person who would fail if no evidence at all were given on either side. Let us consider an example to understand the nuances of Section 102. The state alleges that X has committed theft. If no evidence is adduced from either side, X cannot be convicted of theft, as he is entitled to be presumed innocent until proven guilty. That is, even before the case has begun, there is a presumption in favor of X that he is not guilty and that he is innocent. So, once the trial has begun, if neither the state nor X produce any evidence, then X will be declared innocent. Thus, in case both X and the state fail to produce a single piece of evidence, the judgment will be in favor of X. Thus, the burden of proof lies with the state. One important distinction needs to be maintained between burden of proof in terms of the entire case and burden of proof in relation to particular facts. Let us consider another example to understand this distinction. X accuses Y of theft. Y argues that at the time of the theft he was out of station. In this case, the overall burden of proof that Y has committed the theft is on X. As per Section 103, as Y is alleging that he was out of station on that day, the burden to prove this particular fact lies with Y. Here, even if Y fails to establish his alibi as mandated under Section 103, it will not automatically mean that X will win the case. X has the burden to prove his case regardless of any deficiency or loophole in the argument of Y. X has to prove that it was Y and not anybody else who has committed the theft. The burden of proof on that particular fact as to whether he was out of station or not, which is on Y, does not mean that if he does not discharge that burden, he will be held guilty. However, the burden on X means that if he fails to discharge his burden of proof, Y will not be convicted of theft. Now that we have discussed about burden of proof, let's move on to standard of proof. Standard of proof refers to the degree of conviction which must be adduced through evidence for the court to hold a fact as proved. As we have discussed earlier, holding something as proved includes a measure of estimation. How much evidence must be produced for a court to legitimately estimate that a fact can be said to have been proved? This is the question dealt by the concept of standard of proof, and the answer depends on the nature of the proceedings. Traditionally, there have been two standards of proof to choose from. Firstly, proof beyond reasonable doubt, and secondly, proof by balance of probabilities. The standard of proof beyond reasonable doubt is applied in criminal proceedings. According to this standard, for the court to hold a fact as proved, that fact must have been proved beyond any reasonable doubt. The evidence adduced must not give scope to any reasonable doubt regarding the validity of the conclusions reached. Let's consider an example. X is accused of murdering Y. In this case, the fact that X has murdered Y must be proved beyond reasonable doubt. It will not be enough to prove that it is likely that X has murdered Y, or that the chances of X murdering Y are higher than the chances of him not murdering Y. It must be proved that it is X and X alone who has murdered Y, without there being any scope for doubting that proposition on reasonable grounds. The conclusion should be free from any contradiction. This high standard of proof is applied in criminal proceedings because the consequences of being convicted in a criminal offense is severe and harsh. Before depriving a person of his personal liberty, it is essential to be absolutely sure that he deserves to be so deprived. The standard of proof on balance of probabilities is employed in civil proceedings. According to this particular standard, the only thing which has to be shown is that a fact is more than likely to have happened. Let's consider an example. X accuses Y of breach of contract. Here, X does not need to prove Y's breach of contract beyond reasonable doubt. The judgment will be in favor of X if, after the examination of the evidence adduced by both X and Y, it appears to the court that X's version is more likely than that of Y. In the standard of balance of probabilities, the court balances the weight of evidence produced by both parties and favors the decision that has greater weight of evidence. In this scenario, it is admitted that while both versions of facts are possible, the court is siding with the version which has a greater chance of being true. Now, we come to our discussion on presumptions. In order to provide a status quo from which the proceedings may commence, the law of evidence provides for different kind of presumptions. A presumption is basically assuming certain facts to be true without any evidence to that effect. In fact, on many occasions, it is the presumptions which have a direct bearing on who has the burden of proof. As we have seen, burden of proof rests on the party which will lose if no evidence is produced from either side. Thus, the burden of proof is usually on the party against whom a presumption is operating, or in other words, when the presumption is in favor of X, the burden of proof is on Y. When the presumption is in favor of Y, the burden of proof will be on X. Let us consider this example. When Y accuses X of murder, the burden of proof is on Y, because according to the law, X is presumed to be innocent until proven guilty. The Indian Evidence Act provides three kinds of presumptions. Firstly, rebuttable presumptions at the discretion of the court. Secondly, rebuttable presumptions mandated by law. And thirdly, irrebuttable presumptions. Let us discuss the first kind of presumptions, that is, rebuttable presumptions at the discretion of the court. These presumptions are characterized by use of the phrase may presume. Whenever the law says that the court may presume, it means that whether to presume or not is at the discretion of the court. For example, Section 87 authorizes the court to presume that when it is referring to any map, such map was published by such person which it purports to have been published by. So, if there is a map which was purportedly prepared by Mr. X, the court can presume that it was indeed Mr. X who had prepared that map without inquiring further. However, as has been mentioned, the court is not bound to make such a presumption. The court can very well insist to inquire into the authorship of the map without making the presumption provided under Section 87. Such presumptions are rebuttable in nature, which means that they are not set in stone. If any evidence is produced which contradicts the opinion, the court can discard the presumption and rely on the evidence. Next, we discuss rebuttable presumptions mandated by law. These presumptions are characterized by use of the phrase shall presume. Whenever the law says that the court shall presume something, the court is bound to make the presumption, and the same is not at its discretion. Thus, under Section 113B of the Indian Evidence Act, X is presumed to have caused the dowry death of his wife if it is initially established that soon before her death, X's wife was harassed by X in connection with the demand for dowry. Though the court is bound to make the presumption, such presumptions are rebuttable in nature. That is, if it can be shown that X has not actually caused the death of his wife, then the court can very well say that the accused, that is X, is not guilty of causing dowry death. Now, we discuss irrebuttable presumptions. Now, let us discuss the concept of irrebuttable presumptions. Irrebuttable presumptions are characterized by use of the phrase conclusive proof. For example, Section 113 mandates that a notification in the official gazette of any portion of British territory has been ceded to any native state shall be conclusive proof that a valid cession of such territory has taken place on such date as has been mentioned in the notification. When it is provided by law that fact A is conclusive proof of fact B and fact A has been proved in court, the court has no option but to hold fact B as proved. The court cannot also accept any evidence which contradicts the proof of fact B. As in case of section 113, fact A is a notification in the official gazette. Fact B is the valid secession of a particular territory on a particular date. Once the notification is produced before the court has to hold that a valid secession has been proved. In order to conclude this particular module, we can summarize the primary points regarding the basic principles of evidence law in the following manner. Firstly, legal proof is different from scientific proof, as legal proof is not purely objective in nature. Evidence under the Indian Evidence Act can be of two types: oral evidence and documentary evidence. Evidence can be produced in a court only in relation to two kinds of facts, that is, facts in issue and relevant fact. All kinds of evidence are not allowed to be produced in the court, and this is governed by the rule of admissibility. Burden of proof in a case is with the person who will lose if no evidence is adduced from either side. The standard of proof in criminal proceedings is proof beyond reasonable doubt, and the standard of proof in civil proceedings is proof by a balance of probability. And there are three kinds of presumptions prescribed by law, which can be differentiated by use of phrases may presume, which stands for rebuttable presumptions which are at the discretion of the court, shall presume, which are rebuttable presumptions mandated by law, and conclusive proof, which indicates an irrebuttable presumption. That would be all. Thank you.